I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Before we jump in, a quick heads up. If workplace complaints ever land on your desk, join Joe Beachboard and me on June 2nd for a complimentary live webinar, Getting Investigations Right, a California Employer's Playbook. We will walk through how to scope an investigation, conduct effective interviews, make solid factual findings, and prepare reports that actually hold up, along with the mistakes that create risk. Live Q&A is also included. You can register at employerslawyer.com/investigations, and we have also included the link in the show notes. This is completely complimentary. This program, of course, is sponsored by Employers Lawyer, our new non-traditional law firm built to give employers accessible, affordable California employment law advice with no hourly rates and no retainers. Now, let's get into today's episode. Okay, everybody, last chance agreements. I have been working with these for years, but for most of my career, I've used them when an employee is suspected or confirmed of drug or alcohol abuse at work. So basically, employers use these agreements to say, hey, look, you've screwed up. We know you've screwed up, but we're willing to give you another chance if you're willing to do what we want you to do. And what we want you to do is going to be spelled out in this last chance agreement, okay? And normally what you see in these agreements are things like random testing, which you normally could not do in California unless you're in a safety-sensitive position. And most importantly, the agreement will say if you do anything wrong that you should not have done, you're done, right? Your employment is over. We're finished. Well, recently, it's been clear to me that these agreements are actually good, not just for people who may have drug or alcohol issues, but also for performance issues where you want to make clear to employees, look, this is it. This is your final chance. We're not talking about this again. You either fix it or you're out, right? So you all can figure out how you might want to use them and what their benefit is. Now, remember, when you are using a last chance agreement, you have to know what's happened, right? So once again, like almost everything we talk about on this podcast, you're going to have to do an investigation, right? You're going to have to figure out what happened. Once you do that, though, the last chance agreement is the way to address the situation, right? So these agreements are used instead of immediate termination, right? We're giving employees the opportunity to straighten up and fly right. And as a condition of remaining employed, the employee agrees to certain conditions. Any violation, the agreement should say, will lead to immediate termination. There also oftentimes are acknowledgments in these agreements where an employee says, I admit I came to work under the influence. I admit that I touched someone inappropriately. I admit that I stole $20 from the cash box, whatever it may be. Now remember, in the case of theft, of course, something like that, you may not give them a second chance. Although if somebody tells you a compelling story, I was starving, I needed money for my sick mother, whatever it is, you might decide, okay, I will give them a final opportunity. The beautiful thing about these last chance agreements is that they are a really effective, written, documented way to communicate to an employee that their job is at risk. And it allows you to keep the employee and their institutional knowledge at least for a little bit of time, right? At least until they make another mistake, which of course we hope they're not going to, and many times they don't. So it really is a structure that you're creating that is more than just saying, I'm giving you one more chance. I'm giving you one more chance subject to these terms and conditions. Now, there are some risks here with these last chance agreements, right? You have to be sure that you are using them consistently and fairly, that if you offer them to one employee, you want to make sure that you do so for someone else who is similarly situated. Now, that doesn't mean everybody needs to get a last chance agreement. What it means is if you have two people who engage in the same behavior or the same conduct, and you let one have a last chance agreement, you better have a good reason not to give the other person the last chance agreement, right? The other thing that can be dangerous about these last chance agreements is if you don't write them correctly, you are essentially creating a contract of employment. So you are saying, I'm giving you a second chance and you can be my employee unless you engage in this conduct again, right? So if you write it too narrowly, you're essentially giving them a job for life as long as they don't engage in that behavior. So one of the really important things you need to do is, first of all, be broad. If you violate any other company policy, you're done. It doesn't matter if it's related to what you already did or what we already think you did, or what the investigation revealed that it's more likely than not that you did, all right? So what you want to do is preserve at-will employment. So you literally want to have a sentence in this agreement that says nothing in this last chance agreement changes your at-will employment relationship with the company or with the organization or with the agency or the department. That's critical. Now, a couple of additional critical provisions. First of all, spell out exactly what the employee did. Make sure that you're not being overly general here. Literally say what they did or what you think they did. Be very clear about your expectations for future behavior or performance, all right? What is it you want this person to be doing effective immediately? Make sure you give some measurable conditions and a defined time frame for that compliance, right? So I like the term immediate and sustained improvement. I don't want to just see a little blip of good behavior or good performance. I got to see this change going forward, right? Be very clear that any further violation of company policy or misconduct or failure to behave in a respectful professional way, whatever it is, that's it. They're terminated. And make sure you require that the employees sign this agreement. Acknowledge that they understand what the agreement is and how it's going to work. When you do that, when you create a last chance agreement with these kinds of provisions, you give yourself a really good opportunity to turn the employee around. Remember, you only give a second chance when you actually mean it. If you're just doing this so you can buy a little extra time and you don't have any intent of saving the employee, that often will come out in a deposition or in a hearing. So it's important that you do this in good faith. It's important that you decide for legitimate business reasons why you want to try to save the employee. Now, of course, as I said a minute ago, there's a huge benefit that you can retain institutional knowledge. No doubt about that. But that can't be your only reason for wanting to do it. It's just like when employers will say to me, well, Jen, how many more times do I have to write them up before I can fire them? That's not the point of a write-up. If you're going to fire them, fire them. So the bottom line is these agreements, last chance agreements, can be very effective. As long as they're written appropriately, they contain all of the provisions that we've talked about here today. If they don't contain those provisions, as we've talked about, you could have a discrimination, harassment, retaliation complaint. You could have a situation where you've created a contract of employment. And also, if they're not written well and entered into in good faith, you really lose credibility as an employer. And I don't know about all of you, but I feel like our employees are really valuable, right? I have recruited them, I brought them to the firm, or someone has referred them to us. They're terrific people. They want to work hard. They're doing a good job. I don't want to lose them. So I'm going to use a last chance agreement when it truly is a last chance. I don't want you to overuse this. Many, many issues in the workplace can be dealt with just by verbally counseling somebody, right? Everything you do doesn't have to be in a written document signed by the employee. You can have your own documentation that you keep in your notepad or on your phone in the notes app or whatever you're doing, okay? But when you have a really serious issue, something that you really struggled about whether you should terminate this person, and you decided for whatever reason you want to give them a second chance, that is when you're going to use the last chance agreement. Now, here is the most critical thing. If you tell them that's the last chance, folks, it's got to be the last chance. Otherwise, it's like the boy who cried wolf, right? We cannot be that employer that makes all these idle threats and doesn't follow through with them. That is never going to be an effective way to manage or to lead. So if you're going to do this, if you're going to have a last chance agreement with an employee, you have to enforce it. So if you have a change in leadership, a change in supervisors or managers, you've got to make sure everybody knows. You get a new HR director, right? You've got to make sure everybody knows, hey, listen, this person has a last chance agreement. And when I say everybody knows, I don't mean all their coworkers, obviously, the people who need to know, all right? Because you don't want to end up in a situation where the employee does something they're not supposed to do, you don't let them go, and then 6 months later, they do it again. And this time you do let them go. And they say, well, that's wrongful termination. If that were the real reason you were terminating me, you would have already done that. I have a last chance agreement. So there must be some ulterior motive here. You must be motivated by something else, right? So these agreements can be very, very effective. They can also be dangerous if you don't do them right. So I want to make sure that you take the time to craft them appropriately, use the right terms, store them in the right place, talk to the right people about them. If you do that, this is a tool that works for any misconduct or performance issue, not just drugs or alcohol. That is how it was introduced to me years ago, and I just hadn't thought of it as being such an effective tool for regular misconduct, like sexual harassment type of misconduct or retaliation or that kind of thing. So what you're looking here, folks, is not a little turnaround. You're looking for immediate and sustained improvement. You want to ensure that this employee is permanently turning around their behavior. This is why you don't say the last chance agreement will be in effect for a year. It's never going away. The last chance agreement is never going away. Now, if you're in a public agency, there may be a time limit that will result in the expiration, if you will, of the agreement. It's usually a year. But you're in the private sector, you don't have any of that. So don't negotiate with the employee to say, well, if you do a really good job, I'll take it out of your file. Why? You earned the last chance agreement. It's going to be sitting there. So thank you all very much for joining us here today. Before we wrap up, I want to give you one more reminder. Don't forget to join Joe and me on June 2nd for Getting Investigations Right, a California employer's playbook. If you want your investigations to be consistent, defensible, and done right the first time, this session is for you. Remember, you can register at employerslawyer.com/investigations, or you can grab the link in the show notes, and it's 100% complimentary, sponsored by Employers Lawyer. Thanks, everybody. Go out and have a wonderful rest of your day, and I'll see you next time. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.